The judge's voice sliced through the tense air of the courtroom like a whip. "You step into my courtroom without counsel, Mr. Ellis, and expect to walk away with anything but a contempt charge." Judge Victoria Langford sneered. She saw just another lost kid in a cheap suit. She didn't know this 19-year-old was holding a legal guillotine waiting for the perfect drop. Room 412 of the district courthouse smelled of floor wax, old paper, and impending doom. The gallery was sparse, populated only by a few bored law clerks and a cynical court reporter named Lauren Blake, whose fingers hovered over her stenotype machine with weary indifference. At the plaintiff's table sat Preston Caldwell. Caldwell was a shark in a bespoke Italian suit, a senior partner at a top-tier corporate firm who billed at an exorbitant hourly rate. He was the kind of lawyer who didn't just win cases, he ruined lives. Beside him sat his client, Grant Ellison, a billionaire real estate developer whose aggressive gentrification tactics had displaced hundreds of low-income families. At the defense table sat Cameron Ellis. Cameron was 19 years old. He was black, built like a lightweight boxer, and wearing a navy blue blazer that was at least one size too big, clearly sourced from a local thrift store. His tie was knotted perfectly, but the fabric was frayed at the edges. A stack of manila folders sat in front of him, flanked by 3 legal pads filled with meticulous, cramped handwriting. Judge Victoria Langford peered down from her elevated bench, adjusting her reading glasses. She was a stern, uncompromising woman nearing retirement, known for her blistering intolerance of pro se litigants. In her decades on the bench, she had seen hundreds of arrogant amateurs try to play lawyer, only to be butchered by professionals. Looking down at Cameron, her implicit biases immediately colored her perception. She saw his youth, his race, his mismatched suit, and the neighborhood he came from. To her, he wasn't a defendant fighting for his life. He was a nuisance clogging up her docket. The case was supposed to be a straightforward eviction and civil damages suit. Grant Ellison's development company claimed they had purchased the deed to Cameron's late grandfather's property, a highly contested, lucrative corner lot in a rapidly gentrifying neighborhood. When Cameron refused to vacate, claiming the deed was forged, Ellison's legal team didn't just try to evict him. They had him arrested for criminal trespass, effectively throwing him in a holding cell while bulldozers idled near his home waiting for the green light. The criminal charges had been quietly dropped for lack of evidence, but Caldwell had immediately slapped Cameron with a brutal civil lawsuit demanding $250,000 in damages for interfering with commercial development. It was a classic slap suit. Strategic lawsuit against public participation. The goal was to bankrupt the teenager, break his spirit, and force him to sign away the property just to make the legal nightmare end. Caldwell expected Cameron to either default by not showing up or burst into tears and beg for a settlement. Case number 44B902. Ellison Development Holdings versus Ellis, Judge Langford announced, her voice echoing off the oak-paneled walls. "Counsel, state your appearances." "Preston Caldwell, representing the plaintiff, Your Honor," Caldwell said, rising smoothly. He flashed a brilliant, predatory smile. "And the defense?" Judge Langford asked, turning her gaze toward the lone teenager. Cameron stood up. He didn't slouch. He didn't look at his shoes. He looked directly into the judge's eyes. "Cameron Ellis, representing myself, Your Honor." Judge Langford sighed heavily and audibly. She pinched the bridge of her nose. "Mr. Ellis, I strongly advised you at the preliminary hearing to secure counsel. You are facing incredibly complex civil litigation. Do you honestly believe you are equipped to navigate the rules of civil procedure? I am acutely aware of the rules of civil procedure, Your Honor, Cameron replied, his voice calm, resonant, and completely devoid of the intimidation the judge expected. I have filed my answer to the plaintiff's complaint, along with my affirmative defenses and a counterclaim for malicious prosecution and common law fraud. Caldwell let out a low, patronizing chuckle, loud enough for the court reporter to hear. Your Honor, with all due respect to Mr. Ellis's enthusiasm, this is a court of law, not a mock trial competition. The plaintiff has filed a motion for summary judgment. We have the signed deed. We have the transfer of title. We ask that the court grant our motion, award damages, and put an end to this frivolous delay tactic. Judge Langford flipped open the file. Mr. Ellis, opposing counsel, has filed a motion for summary judgment. Have you prepared a response, or should I rule on this right now? She fully expected him to ask what summary judgment meant. She expected him to stammer about fairness, to offer emotional pleas instead of legal arguments. Instead, Cameron reached into his center folder, pulled out a thick, perfectly bound document, and handed copies to the bailiff to distribute. I have filed a memorandum in opposition to the plaintiff's motion for summary judgment, Your Honor, Cameron said smoothly. Furthermore, I have filed a cross motion for summary judgment on my counterclaim accompanied by sworn affidavits and a request for judicial notice regarding the plaintiff's chain of title. Caldwell's smirk faltered for a fraction of a second. He glanced at the document the bailiff handed him. It was properly formatted. The citations were in perfect Blue Book format. Judge Langford raised an eyebrow, scanning the first page of Cameron's brief. Did someone help you write this, Mr. Ellis? A paralegal? A law student? No, Your Honor, Cameron replied quietly. I wrote it. Well, the judge said, her tone dripping with skepticism, filing paper is one thing, arguing the law is another. Mr. Caldwell, the floor is yours for your motion. Caldwell stood, buttoning his jacket. He decided to crush the kid immediately. He launched into a rapid-fire, highly technical argument, burying the courtroom in dense legal jargon. He cited obscure state precedents regarding property transfers. He spoke of bona fide purchasers for value and statute of frauds. It was a deliberate tactic designed to confuse and overwhelm the teenager, to make him realize he was swimming in the deep ocean with a great white shark. Therefore, Your Honor, Caldwell concluded, pacing confidently in front of the bench, because the defendant has failed to produce any legally admissible evidence that the signature on the deed is invalid, there is no genuine dispute of material fact. As a matter of law, the property belongs to my client, and Mr. Ellis is liable for the damages caused by his stubborn, unlawful occupation. I reserve the balance of my time. Caldwell sat down, leaning back in his chair and crossing his legs. He didn't even look at Cameron. Judge Langford turned to the defense table. Mr. Ellis, you have the floor. Try to stay on topic. I don't want to hear about how unfair life is. I only want to hear about the law. Cameron stood up. He didn't bring any notes with him to the podium. May it please the court, Cameron began, resting his hands lightly on the sides of the wooden podium. Mr. Caldwell asserts that there is no genuine dispute of material fact regarding the validity of the deed. He relies heavily on the presumption of regularity attached to notarized documents, citing Benson versus Thompson. Caldwell's eyes narrowed. The kid had actually understood his citation. However, Cameron continued, his voice echoing with absolute authority, Mr. Caldwell conveniently ignores the fact that the presumption of regularity is completely shattered when there is clear and convincing evidence of extrinsic fraud. I direct Your Honor's attention to Exhibit C of my opposition. Judge Langford rustled through the papers, pulling out Exhibit C. "This is a copy of the deed. Look at the notary stamp, Your Honor," Cameron instructed. "The stamp belongs to a Mr. Bradley Coleman. The date of notarization on the deed is the date Mr. Caldwell claims my grandfather signed away his home." "Your point, Mr. Ellis?" the judge asked impatiently. "My point, Your Honor, is that on that date, my grandfather was in the intensive care unit at Mercy General Hospital, completely sedated and intubated due to severe pneumonia. He physically could not have signed that document." "Objection!" Caldwell snapped, jumping to his feet. "Hearsay. Mr. Ellis is attempting to introduce medical conditions without an expert witness or authenticated records." "The records are authenticated, Your Honor," Cameron countered without missing a beat. "Exhibit D contains the certified medical records from Mercy General, complete with an affidavit from the hospital's custodian of records, strictly adhering to the business records, exception to the hearsay rule under Rule 800-36 of the Rules of Evidence." Judge Langford flipped to Exhibit D. Her eyes widened. She stared at the hospital records, then looked up at Cameron, seeing him clearly for the first time. The annoyance in her eyes was suddenly replaced by sharp, calculating intrigue. "These records indicate the patient was unconscious." "Exactly," Cameron said. "But the fraud goes deeper. Let's return to the notary, Bradley Coleman. If Your Honor turns to Exhibit E, you will find certified travel records from the State Department. On that same date, Bradley Coleman was not in this state. He was not even in this country. He was on vacation in Cabo San Lucas, Mexico. His passport was scanned at customs and he did not return until later." The courtroom fell dead silent. Lauren Blake, the court reporter, actually stopped typing for a second to stare at the teenager. Grant Ellison, the billionaire developer, turned fiercely to his lawyer, his face flushing red. Caldwell's confident posture had evaporated. He grabbed the documents and scoured the pages, his heart hammering against his ribs. "Your Honor," Caldwell stammered, attempting to recover his footing. This is an ambush. The defense never produced these travel records during discovery." "Because you never asked for them," Cameron shot back, his voice slicing through the room like a razor. "You propounded exactly one set of interrogatories, which I answered. You assumed I wouldn't know how to issue subpoenas, so you didn't bother checking my work. I subpoenaed the flight manifests and customs records and served copies to your office via certified mail. I have the return receipt right here, signed by your paralegal." Cameron held up a green postal receipt. Karma had just walked into the room, and she wasn't wearing a blindfold. Caldwell's fatal flaw, his absolute prejudiced arrogance, had led him to ignore mail from a pro se defendant. He had tossed Cameron's envelopes into a pile, assuming they were just handwritten ramblings. He hadn't even looked at them. Judge Victoria Langford slammed her hand down on the bench. Her face was dark with fury, but not at the teenager. She glared at the high-priced lawyer. "Mr. Caldwell," the judge's voice was dangerously quiet, "did you submit a forged, fraudulently notarized deed to this court in support of a motion for summary judgment?" "Your Honor, my firm received that deed from the title company. We had no reason to believe—" "You have a duty of candor to this tribunal," Judge Langford roared, her voice echoing like a thunderclap. "You filed a lawsuit demanding $250,000 from a teenager based on a document signed by a comatose man and stamped by a notary who was out of the country, and you failed to review the defendant's discovery disclosures because you couldn't be bothered. Sit down." "Your Honor, I must formally request an immediate recess," Caldwell pleaded, panic leaking into his voice. "I need to confer with my client regarding these These fabricated accusations. They aren't fabricated, Preston, Cameron said. It was the first time he had addressed the lawyer by his first name. It wasn't a sign of respect. It was a stripping of title. And you know, they aren't because in Exhibit H, you will find a sworn deposition from Mr. Tyler Brooks. Ellison's head snapped up. Tyler, he whispered, the blood completely draining from his face. Tyler Brooks was the vice president of acquisitions for Ellison Development Holdings until he was abruptly terminated months ago, Cameron continued, turning a page on his legal pad. Mr. Brooks was thoroughly dissatisfied with his severance package. More importantly, he was deeply troubled by the instructions he received from Mr. Ellison. In his affidavit, Mr. Brooks details the exact internal company protocol for identifying vulnerable, high-value target properties. He outlines the payment structure used to funnel money to Bradley Coleman to procure blank, pre-stamped notary seals. Judge Langford read the affidavit in silence. The only sound in the room was the hum of the air conditioning and the frantic tapping of the stenographer's keys. When she finally looked up, her expression was impenetrable. Mr. Caldwell, the judge said quietly, are you aware of the crime-fraud exception to attorney-client privilege? Caldwell swallowed hard. Yes, Your Honor. Good, because if your firm knowingly participated in this scheme to weaponize the judicial system against the elderly and the vulnerable, if you used my court to launder stolen real estate, I will personally see to it that you never practice law in this state again. Your Honor, my firm was completely compartmentalized from the acquisition process, Caldwell stammered, throwing his client under the bus with breathtaking speed. We merely handled the civil litigation based on the documentation provided to us by Ellison Development. If there is fraud, we are victims of it as well. You cowardly son of a bitch! Ellison roared, lunging out of his chair toward his lawyer. The bailiff, a burly man named Thomas, was there in an instant, grabbing Ellison by the shoulder and shoving him hard back into his seat. Stay seated, sir, or you're going to a holding cell right now, Thomas barked. Ellison sat, breathing heavily, glaring at his lawyer with pure, unadulterated hatred. The alliance had fractured. The rats were beginning to cannibalize each other. Cameron watched the implosion of the plaintiff's table with a calm, stoic expression. He hadn't raised his voice once. He hadn't pounded the podium. He had simply built a cage out of paper and facts and waited for them to walk inside. Caldwell, desperately trying to salvage whatever was left of his life, scrambled for a lifeline. He realized that if this hearing proceeded, the rulings would become permanent public record, a death sentence for his career. Your Honor, Caldwell said, his voice trembling, in light of the newly discovered evidence presented by the defense, the plaintiff formally moves for a voluntary dismissal of this lawsuit without prejudice pursuant to Rule 41. It was a cowardly retreat. A dismissal without prejudice meant the lawsuit would be dropped, but they could theoretically refile it later. More importantly, it would allow them to run out of the courtroom, regroup, and try to bury the evidence before the authorities got involved. Nice try, Cameron muttered softly into the microphone. Judge Langford looked at Cameron. Mr. Ellis, do you have an objection to the plaintiff's motion for voluntary dismissal? I fiercely object, Your Honor, Cameron said, standing tall. Under Rule 41A(2), once a defendant has filed an answer and a counterclaim, an action may be dismissed at the plaintiff's request only by court order, on terms that the court considers proper. I have filed a counterclaim for malicious prosecution, fraud, and a quiet title action. If you allow them to dismiss this case and walk out of here, they will shred every remaining document in their corporate office. They will wire their money to offshore accounts, and they will leave my grandfather's name tied up in a fraudulent title dispute for years. Cameron paused, taking a slow breath. For the first time, a crack of human emotion showed through his impenetrable legal armor. My grandfather, Marcus Ellis, worked double shifts at a steel mill for decades to pay off the mortgage on that house. He built the porch with his own hands. When he was lying in a hospital bed, suffocating from pneumonia, Mr. Ellison saw an opportunity. He saw a man who couldn't fight back. He saw a neighborhood that the city had forgotten. And he saw a 19-year-old kid that he thought he could crush with expensive legal stationery. Cameron looked directly at Grant Ellison. You thought, because I didn't have a JD from Harvard, because I lived in a zip code you were trying to bulldoze, that I would just roll over. You used the law as a weapon of terror. But you forgot one thing, Mr. Ellison. What's that? Ellison spat, his voice dripping with venom but betraying a deep, fundamental terror. The law is a weapon, Cameron said, his voice dropping to a chilling register. But I learned how to shoot. Cameron turned back to the judge. Your Honor, I ask that you deny the plaintiff's motion for voluntary dismissal. I ask that you rule on my cross motion for summary judgment right here, right now. I have provided uncontroverted, sworn, documentary evidence of extrinsic fraud. I am asking for a declaratory judgment voiding the forged deed, returning the title to my grandfather's estate, and granting my counterclaim for compensatory and punitive damages. Judge Victoria Langford sat back in her high leather chair. She looked at the wreckage of the plaintiff's case. She looked at the sweating, defeated billionaire and his terrified, compromised lawyer. Then she looked at Cameron Ellis. She felt a deep, burning shame for the assumptions she had made when he first walked into her courtroom. She had seen a victim. She had seen an annoyance. She had been entirely wrong. He wasn't just a survivor. He was an architect of total legal destruction, and he was just getting started. The plaintiff's motion for voluntary dismissal is denied, Judge Langford announced, her voice ringing with absolute finality. Caldwell buried his face in his hands. Furthermore, the judge continued, picking up her pen, having reviewed the sworn affidavits, the medical records, the travel logs, and the bank statements provided by the defense, I find that there is no genuine dispute of material fact regarding the utter fraudulence of the deed presented by the plaintiff. She looked fiercely at Ellison. Mr. Ellison, your actions are repugnant. You are a parasite disguised as a developer. The court grants the defendant's cross motion for summary judgment in its entirety. The deed is hereby declared null, void, and legally fictitious. The title is quieted in the name of the estate of Marcus Ellis. Cameron let out a slow, quiet breath. He had done it. He had saved the house, but the judge wasn't finished. Regarding the defendant's counterclaim for malicious prosecution and civil fraud, Judge Langford said, her eyes flashing, I'm entering a default judgment against the plaintiff on the issue of liability due to the egregious spoliation and fabrication of evidence. We will schedule a hearing for damages, but I will tell you right now, Mr. Ellison, under the state's elder abuse statutes, I will be legally obligated to award treble damages. You will be paying Mr. Ellis 3 times the value of whatever harm you have caused. Ellison looked like he was going to be physically sick. Finally, Judge Langford said, her gaze shifting to Preston Caldwell. The lawyer flinched under her stare. Mr. Caldwell, I'm issuing an immediate order to show cause as to why you and your firm should not be heavily sanctioned under Rule 11 for filing frivolous, fraudulent pleadings. But frankly, sanctions are the least of your worries. The judge turned to her clerk. Martha, please contact the United States Attorney's Office for the District and the Economic Crimes Division of the State Attorney General. Send them the entire transcript of today's proceedings along with copies of all defense exhibits. Inform them that this court has made a preliminary finding of criminal fraud, perjury, and potential racketeering. Caldwell stood up, his legs shaking. Your Honor, please. Court is adjourned. Judge Langford snapped, slamming her gavel down with the force of a thunderstrike. She stood up, her black robes billowing, and looked down at Cameron Ellis one last time. The strict, cynical facade she had worn for decades cracked, and she gave the young man a small, deeply respectful nod. Well litigated, counselor, she said quietly. Cameron packed up his thrift store briefcase in silence. As he walked down the center aisle of the courtroom, past the hyperventilating billionaire and the ruined corporate lawyer, he didn't gloat. He didn't smile. He just pushed open the heavy oak doors and stepped out into the hallway, the rightful owner of his grandfather's legacy, having beaten the devil at his own game. The heavy oak doors of room 412 swung shut, but the shockwave Cameron Ellis had just generated was already tearing through the city's financial and legal districts. He walked down the marble corridor of the courthouse, his footsteps echoing in the cavernous space. Sitting on a wooden bench near the elevators was Tyler Brooks, the ousted vice president of Ellison Development Holdings. Brooks stood up as Cameron approached, a nervous, hopeful look in his eyes. Did she admit the affidavit? Brooks asked, his voice tight with anxiety. She admitted everything, Tyler, Cameron replied, his tone steady and devoid of triumph. The judge is sending the transcript to the United States Attorney. You need to call your defense counsel right now and negotiate your immunity deal before Ellison tries to pin the entire operation on you. Brooks exhaled a shaky breath, running a hand through his thinning hair. You actually did it. You broke him. No, Cameron corrected, pressing the elevator button. He broke himself. I just handed the court the hammer. In the wake of the hearing, the legal fallout began. Judge Langford was as good as her word. The transcripts and evidence binders landed on the desk of the State Attorney General. The Federal Bureau of Investigation's White-Collar Crime Division executed a no-knock raid on the corporate headquarters of Ellison Development Holdings. Agents hauled out dozens of servers and hundreds of boxes of physical files. The financial panic was instantaneous. Real estate development relies entirely on leveraged debt and institutional trust. When news of the forged deeds broke, major title insurance companies immediately suspended all policies tied to his company. Without title insurance, Ellison's properties were utterly radioactive. Banks could not issue mortgages on them. Buyers could not purchase them. Major banks called in their commercial loans, citing moral turpitude and criminal fraud breaches in their lending covenants. Grant Ellison's 9-figure empire went into a catastrophic freefall. He attempted to liquidate his personal assets, but the federal government had already frozen his accounts under the RICO statute, pending a massive civil asset forfeiture. Ellison, a man who had spent his entire life displacing the poor, was suddenly unable to even pay his own electricity bill. For Preston Caldwell, the descent was even more humiliating. The State Bar Association did not wait for a criminal conviction. In a highly publicized disciplinary hearing, Caldwell was stripped of his law license. The senior partners at his prestigious corporate firm, desperate to avoid the federal crosshairs, turned on him completely. They locked him out of his corner office, seized his internal emails, and handed them directly to the prosecution on a silver platter. Caldwell was indicted on multiple counts of conspiracy to commit wire fraud, subornation of perjury, and racketeering. Faced with the prospect of decades in a federal penitentiary, Caldwell's arrogance finally shattered. The apex predator wept openly in federal court, agreeing to a plea deal that required him to testify against his former client. Grant Ellison was ultimately sentenced to years in federal prison, his legacy reduced to a cautionary tale taught in first-year law school ethics classes. But the true victory belonged to the community. When the damages hearing finally arrived in Judge Langford's courtroom, Grant Ellison was practically destitute. His assets seized or tied up in federal litigation. But Cameron had anticipated this. He didn't just sue Ellison. He pierced the corporate veil and named the institutional investors who had knowingly turned a blind eye to the fraud. The court awarded Cameron treble damages, 3 times the assessed value of the home, plus punitive damages for the sheer malice of the elder abuse. Cameron did not spend the settlement on sports cars or luxury watches. He understood that the systemic rot went far deeper than one corrupt developer. He took the capital and established the Marcus Ellis Foundation, a non-profit legal clinic named after his grandfather. The clinic was dedicated solely to defending low-income families against predatory gentrification, deed theft, and illegal evictions. He hired aggressive, hungry young attorneys to staff the clinic, but he remained the chief strategist. He taught them the lesson he had learned in room 412. The law is not inherently just. The law is simply a machine. It favors the wealthy, the connected, and the ruthless. But if you are willing to spend the sleepless nights reading the statutes, if you are willing to master the brutal geometry of civil procedure, you can take control of the machine. You can turn the weapons of the powerful against them. When the time came for him to receive his Juris Doctor degree, graduating at the very top of his class, Cameron didn't take a job at a white-shoe corporate firm. He didn't want a corner office overlooking the city. He wanted to be down in the trenches, standing between the bulldozers and the front porches of the people who built the city. He became the very thing that arrogant men in expensive suits feared the most. A brilliant mind that could not be bought, could not be intimidated, and would never, ever back down from a fight. Justice is rarely handed down willingly. It must be extracted by those brave enough to learn the rules of the game. Cameron Ellis did not just save his grandfather's home. He entirely dismantled a predatory machine built on sheer arrogance. This case stands as a brutal reminder to the powerful. Never underestimate the quiet determination of a young mind with nothing to lose. Because absolute karma always collects its debts.